Hello, my name is Roxane Farmer and I'm an associate at the Nieves Law Firm, and today I'm going to be talking about wobblers.
A wobbler is a crime that could be charged either as a misdemeanor or as a felony. And the difference between a misdemeanor and a felony is that misdemeanors are typically not punishable by more than 1 year in the county jail, and a felony is punishable by state prison. The way that you assess whether or not a charge is a misdemeanor or a felony is by looking at the language in the Penal Code statute, and there are also legal aids that can assist in determining whether or not a charge is a wobbler. If a charge is a wobbler, the Penal Code will say something like punishable in the county jail or a state prison sentence. Common examples of wobblers are burglary, evading in your vehicle, and criminal threats. And some common non-wobbling offenses are murder, although vehicular manslaughter can be charged as a misdemeanor or a felony, and false imprisonment, which can be charged either as a misdemeanor or as a felony, but does not wobble when you read the plain language of the Penal Code statute. You can get a felony reduced to a misdemeanor via a motion called a 17B motion. That's 17B of the Penal Code, and it's a request that the court take into consideration the nature of the offense, the circumstances, the facts of the case, your compliance with probation, any criminal history, and your personal history, and make a decision about whether or not your case should be reduced from a felony to a misdemeanor. You can also have a misdemeanor offense reduced to an infraction through something called a 17B motion. And there are certain offenses that are eligible to be infracted, and if it is not in the code, in 17D, then it's not eligible to be infracted. The benefit of reducing a felony to a misdemeanor is that you are avoiding state prison, and the benefit of reducing a misdemeanor to an infraction is that you are facing a financial penalty, nothing more than a parking ticket. Even if you're unsuccessful in a 17B motion before you are convicted, you can still ask for a 17B motion post-conviction. There are some requirements. For example, you can't have served any state prison time, and there are other requirements as well, but in many cases, you can still ask for a reduction post-conviction by way of expungement.
The Nieves Law Firm is an Oakland-based criminal defense law firm representing the San Francisco Bay Area and surrounding counties and throughout California. If you or a loved one has been accused of a crime, have an open case, or have a criminal record you want cleaned up, please call now to schedule a free 30-minute consult.